Uh, Good morning. I should start by thanking our very kind hosts and organizers, the two organizers, TCO and the University of Oxford, for involving me in this project and for inviting me to present on this chapter that, as you've gathered, we've co-authored. I had the pleasure to co-author, I should say, with your colleague Samuel Engblom. What I will try to do, rather than take you through the various paragraphs and sections of the chapter, is to try and discuss some of the key ideas that we developed in that chapter in the context of a process that, as I've heard from the solicitor that represented the unions in the original Viking case, is very much an ongoing process. So Jeremiah, very much suspect or fear that 10 years from now you could very easily put together with Mark another edition of the series again on Viking and Laval, and it would still be a very timely project. In order to do this, I will... I thought this was going to go wrong. In order to do this, I will take you to a quote from the single market paper produced by Mr. Mario Monti in 2010, in which he clearly and correctly noted that the cases of Viking and Laval had exposed the fault lines that ran between the single market and the social dimension at a national level. In two ways, he would say. The first one is the traditional social dumping questions that the two cases and the following cases raise, and also this tension between collective labor rights and market freedoms, on which I shall say something in a couple of minutes. His intuition back then was that either the Court of Justice comes to grips with these challenges, or the EU lawmaking and policy-making institutions will have to deal with them through policy actions. The scope of further policy action should be explored. As I've said, the two key fault lines identified by Mario Monti, quite correctly, were the social dumping concerns that emerge from these cases, the idea that, as Samuel mentioned, some service providers could effectively attempt and successfully attempt to import the regulatory framework of the country of establishment, the country of origin, into host country, with negative effects in terms of terms and conditions, in terms of the competition between terms and conditions of different workforces. And the other one, very vividly brought to the surface by both Viking and Laval, the conflict between collective labor rights and market freedoms. We typically look at the conflict between the right to strike and the right to take industrial action, but I think in Sweden it's obviously clear that there was also a big conflict between collective bargaining, or some particular forms and traditions of collective bargaining, and market freedoms. Now, the key policy actions that were envisaged in the last 5 years are fairly well known and very well covered by the other chapters in the collection of book, the Enforcement Directive, and the, I should say, abortive, I think, Monti II proposal. It's very hard to talk about an infanticide here, I think. It was really never I think, delivered other than as a early conception, but it clearly saw its own death in the making. Now, we try to grapple with some of the issues in a chapter emerging both from the Enforcement Directive, partly Monti II, but clearly there are some other chapters that deal specifically with that. Our conclusion, however, is, I think, not on the very enthusiastic end of the spectrum, to say the least. Certainly when it comes to Monti II, I think the Enforcement Directive it is fair to say, or one should be fair to it and say, that it may open some avenues for national productive engagement or contestation with some of the key principles introduced in Viking and Laval, but these would be limited actions, I think, in our view. What I would like to focus instead is on another part of that quote from Mario Monti of 2010. Before he mentioned the possibility of taking up further policy and legislative action, he would actually say that these Viking and Laval predate the entry into force of the Lisbon Treaty, predate the adoption of the European Charter of Fundamental Rights as a binding document, and this idea of social market economy. He very much felt that these elements should shape a new legal context in which these concerns, the two key concerns, social dumping and the conflict between collective rights, collective labor rights and market freedoms, should hopefully find an adequate response. And I very much felt that, we very much felt that in reading against this document, this is really something that called back into the equation the European Court of Justice. Okay? And the European Court of Justice, like most European but also national courts, is sensitive to legal and political changes. And these changes can come from different directions, but I think there has been, of course, a legal change. There have also been harsh reactions, fair but harsh reactions, I think, to its jurisprudence in Viking and Laval. So what we wanted to do is explore this new legal, but also this new legal and political context, and how it may pan out, I think, in Luxembourg. So we have three fairly recent cases that have dealt with these issues, and all of you would be familiar with them, I'm sure. Jeremiah's mentioned the FNV Dutch case. There is a Belgian case decided in December, the Clerk case, and the more recent Finnish case, which I will not try to pronounce. I'll just refer to it as the ESA case. Now, I think all of them suggest or betray a new type of engagement on the part of the European Court of Justice with some of the issues that underpinned Viking and Laval, but also some of the issues that have emerged from the practice of the application, and sometimes the abuse of the posting of workers' arrangements in Europe, especially through the use of what in a chapter referred to as false or bogus self-employed workers. And what we've been trying to do, and it's just the beginning of a process, some of these cases are quite fresh, is to see what these decisions may reveal in terms of moving forward this jurisprudence. So very, very quickly, the first case, the facts of the case are quite straightforward. There were some nominally self-employed artists who were trying to, whose minimum terms and conditions of employment, especially in respect of wages, were regulated through collective agreements. However, the status of self-employed workers put them between the hard place of the European competition law legislation and its jurisprudence in cases like Pavlov, that basically saw the collective organizations as not being trade unions, but as effectively amounted to undertakings and really cartels because of their self-employed status. And this is really what the employers were trying to argue very, very forcefully before the Court of Justice of the European Union. This is a Pavlov situation. And fortunately, the European Court of Justice did not have a Pavlovian reaction to this call. And instead, it really tried to pitch this scenario between Albany and Allenby. On the one hand, said, look, these are not really genuine self-employed workers. Okay, this is almost an Allenby situation. Okay, their independence is merely notional, and therefore we will not approach their organizations and their collective arrangements as amounting to undertakings or cartels or an abuse of a dominant position according to European competition law. We'll pitch it in the Albany exception. Okay, it's an interesting decision, but I think, it's an interesting decision for those who deal with self-employed, full self-employed status and the Albany kind of situation. But if we transpose this in the posting of workers scenario, the big challenge is whether the European Court of Justice will be prepared under the same kind of reasoning. For instance, to say that this is not really a posting situation, these are not service providers. We have a situation where the company is really posting workers and therefore fitting under the free movement of workers conceptual apparatus and normative apparatus of European law regulation, which we feel, and we have argued in other writings we've done together, is very much and much more anchored to the equal treatment principle, whereby, I've moved from my country of origin to the United Kingdom, and I never claimed that give me an academic position because I'll do more or less the job. I'll do the job more or less competently, but for half the wage, according to the Greek wages legislation, which we're now certainly the cheapest workers in old Europe, for sure. So I struggle to see the European Court of Justice taking such a bold step if it were to be challenged by a factual scenario where the posting of workers is being seen as a posting of full self-employed, as a full self-employed arrangement, and the court would have to say, look, this is really a free movement of workers situation. We're not talking about free movement of services at all. The de Klerk case, I think of the three cases, this is probably the one that I find more interesting, and I can see, although it's fairly minimalistic and there's nothing terribly exciting about the factual scenario, but I can see the European Court of Justice engaging with some of the of its old established case law, such as the Arblad and Leloup cases, in a way that I think has led to different result and positive result in this case. And this may actually show a tendency to be far more respectful vis-a-vis the nitty-gritty aspects of labor law that actually the European Enforcement Directive is also looking at. So that could be, this case, the de Klerk case, could be opening an interesting space for national inspectors, national authorities, national trade unions to explore further. Very quickly, the ESA case, I think it's a very interesting case and it's an important development, but again, the context, the Finnish industrial relation context, is one that is particularly congenial to the type of tests that the European Court of Justice has developed for collective agreements of the host member states to be applicable. This is a collective agreement that meets those criteria of the directive as interpreted by the European Court of Justice of universality and erga omnes application because of the Finnish industrial relations tradition and the 2001 law. What is interesting from a British perspective is that it actually dealt quite effectively with some aspects of the definition of wage that I think were very much there behind this Lindsay dispute. Should accommodation be part of the wage package? Should it be considered as forming part of the wage package or not? And these were strong cases. We're talking about criminal prosecutions under Belgian law. So it was a fairly high threshold. And I thought that in this case, the court was quite brave, but bearing in mind a particular industrial relation context of Finland. So trying to rekindle this, to relink with our chapter very briefly for a couple of minutes, we use this quote from Alain Soupiot's works, that part of the function of labor law is that of civilizing labor relations. And we think, I mean, being labor lawyers would say that, but we think it's also about civilizing market societies at large. And the way we felt that in the context that we're looking at, labor law principles could act as important normative principles for reform is twofold. We have argued in this chapter and in other work we've done together that a key labor law principle should be used as a guide for both formulating instruments such as the Posted Workers Directive, but also interpreting them, should be the equal treatment principle. And this idea that when a workforce move from a country to another country, so from a home country to a host country, it should be treated on the basis of the standards applying in the host member states. This is obviously true when the workforce is moving under the umbrella of EU free movement of workers legislation, but it should also be true when it comes, and to a certain extent it is true, when it comes to the free movement rights exercises and the free movement of establishment of natural persons. It should also hold true, and very much so, when this workforce is moving under the umbrella of free movement of services and under the rules of the Posted Workers Directive. The second principle, it's perhaps broader and more ambitious, but it's linked to the idea that European integration should be using social rights, labor law, as a compass for its future moves. And this is something that I think it may be tried to say in a trade union environment or amongst labor lawyers, but there has been a perception, and the same perception was very much noted by Mario Monti, who is not, is many things, but not a labor lawyer, the crisis of legitimacy of the European integration problem at the moment, it's a very deep one, and I'm not saying this as a Greek national at all, but I think a good compass for driving the process of European integration could be the respect for labor rights, and I'm not just talking about fundamental labor rights that sit somewhere there in the supranational universe, but I'm talking about national traditions of industrial relations, about the nitty-gritty details that as labor lawyers we get excited about, but seem to go amiss whenever you're talking about the bigger picture of supranational integration. And I think on this somber note, I'll probably finish my presentation and I take questions if there are any, or later on.
Perhaps after.
Okay, thank you very much.
Thank you. Thank you very much. There will be room for questions, but first I invite Jörgen Hettne from the Swedish Institute for European Policy Studies. I don't know your actual title. Are you a professor now?
Associate professor.
Associate professor. I'm sorry.
Okay, I think now you hear me better. And we just find some space. Is it yours? No, put it there. So I will give some comments to this chapter. And I think I will, as a general EU lawyer, I will also bring a more general perspective on these issues. And more like than whether here like in internal market perspective, I would say. But I will try to comment and I try to see how I can contribute to the more future debate on these issues, which are mentioned also in this chapter. I would also like to say that I think that the initiative of this book is very good, and I think to have that multidisciplinary perspective on these issues are extremely important. And then I mean with disciplinary, that there are maybe different perspectives from labor lawyers and other union law lawyers and so on. But I will start with some kind of obvious internal market logic, and that is the division between the four freedom. We have the free movement for goods, service, and capital, and the intention is to create an internal market then without any internal borders. That we know, and that should then enhance cross-border movement, but also cross-border competition. So that is the intention of the internal market to a very big extent. Then, which is more important in this context, I think, that is the difference between these freedoms, because we have goods, service, and capital, which are really cross-border activities, and they are based on what we call the mutual recognition principle. And the mutual recognition principles mean that we must have at least we have two different legal orders applied at the same time. So we have a home state and we have a host state, because there are a cross-border situation, and we must decide which law will apply on different situations. So that is for the freedoms, then goods, service, and capital. What is interesting to think about is that there are another principle which are applicable for other freedoms, and that is then free movement of persons, right? And persons can be workers, and it can also be establishment, because person can also be companies which are established in another member state through establishment. And when we apply the law in that context, then it's not a principle of mutual recognition, but more, we can call it national treatment, because we should apply national law. It's only one set of law in that case, and that is applicable for this situation. And I think the equal treatment principle, which Nicola and Samuel is asking for, is very present there. That is really what they like. That principle apply for that labor market in the host state, but which is also the new home state in that context, because you have established yourself there, or it's a worker who is integrated in that labor market. So I think that is important to keep in mind when we're thinking about how we can change this. So what is a posted worker? That is also important. A posted worker is, from a union law perspective, not a worker, right? Where the four freedoms and workers are going to another member state, that the posted worker is not a worker, it's an asset of service provider. So it belongs to the service and is taken from one member state to the other, but it's still services. And that is the core of the problem. We are talking about services and not free movement of workers or establishment. So that is also one point. And that was maybe not obvious, but that has been developed then in the case law, and we know the Rush Portuguesa case, which is, I think, the first one there the court said that this is actually an asset of the service provider, it's not a worker. And you can see some hesitance from the court when it at the same time say that the labor law, collective agreement and so on in the host state should have some kind of application. Because if you think about the mutual recognition principle, you know that the main road is actually the home state. So that should be enough. And then we have to divide how much from the home state and how much from the host state of the law will be applicable. And if you look at that background, what is then the Posting of Workers Directive? That is a directive who tries to make this more clear and understandable, because it's obvious there is some kind of special situation when it's posting of workers. It's services, yes, but it's not pure services. It's something which is related to free movement of workers and establishment at the same time, but it's still services. And then the directive tries to then put in advance what part of the law in the host state will be applicable, even though the home state is still the main law to apply, right? And that is done in advance. And why I'm saying that is to explain that I don't think this directive is not a typical harmonization directive, which are about social standards in all the member states and will affect national law in all the member states. Is something else, is something much more specific. This directive is trying to make the treaty articles applicable in a more predictable way. So it's helping the treaty article, but it will never be there to replace the treaty article. And that is a perspective from the Court of Justice in the Laval case, for instance. It's applying the directive, but at the same time, the treaty article. Because this directive is not taking over the treaty article. It's just trying to make it facilitate to apply them. And I think it's still about mutual recognition, but it's then done in advance. So we know in advance what kind of law will apply from the home state and host states. I don't think it's correct to call it then a principle of country of origin principle, because I think that is different than we are talking only about the home state. This is division between the two different legal orders, but they are applied at the same time. And it's not traditional harmonization, which means that it's difficult to then measure it as a maximum or exhaustive harmonization or minimum harmonization. It's not really that kind of perspective, but it's linked to the application of the treaty articles. Okay, so far so good. Legal certainty, as I said, but you can also see that as business predictability, and that's part of legal certainty. That companies in one member state should know what kind of law from the host member state will actually be applicable if I will, with a bid in a public procurement procedure, for instance, win that contract. I must know beforehand what kind of law will apply, because I want to calculate my costs beforehand, right? So what is the problems? And I think they are very well illustrated by Nicola and Samuel in the chapter. That is actually that one which is not mentioned clearly, but I think is there still, is that the old directive is very difficult to change, because we are 28 member states and we need qualified majority, and there will be different views on what this is about. So that is one problem. You can think about changing what should be in the what should be applied by the host state legislation and home state. You can still change that if you change the main directive, but it's not so easy to decide that. I also think that one important thing is that maybe the directive is over-applied in a way, because I think it's applied in situations which are not really posting of workers sometimes, because it's so easy to look at the directive. If it's a situation about establishment, if it is a situation about free movement of workers, the directive doesn't apply. But I think it's applicable still sometimes in practice for that kind of situation, and that is important for the future, I think. Another problem is, of course, enlargement, and as is always the case with the principle of mutual recognition, that make it possible to have regulatory competition, and competition between laws in the member state. And there is always a risk of race to the bottom, that you try to go to the member state where you have the least demanding conditions for businesses, and that can be low social standards, right? So that is, but that is increased, I think, after the adoption of the directive by enlargement, and also by the development of union law, maybe in general, which are making services maybe more important in between establishment and free movement of workers as one of the freedoms. So what can you do from that perspective? And I think I can agree on many of the things which is said in the chapter then. I think that the boundaries between free movement of services and establishment can be much more clarified. We're still waiting for the Court of Justice to give more precise guidelines on that, but I think the directive in Article 4 is trying to then enhance that perspective, that actually all the situation is not posting of workers. If then the company who is posting workers, it is at the same time established. It can be a secondary establishment in other member state. It cannot be posting of workers. Then the national labor law will apply fully, of course with the condition that it cannot be discriminatory, and there can be some aspects of proportionality also there, but it's a different situation because we only have one set of rules applied in that situation. We don't have the double application of two different legal orders. So Article 4 in the Enforcement Directive is for that purpose an important instruction that we should clarify the line between establishment and free movement of services. There is also talk about abuse in many situations, and that is that some kind of artificial constructions are made up by companies to make use of this Posting of Workers Directive. And it's mentioned by the Commission, it's mentioned by the authors of this chapter also. And we should also remember there is one general principle of union law which is called abuse of law, the prohibition on abuse of law. And that has not, I don't think, been applied. But if we have that kind of construction which is not really in accordance with the purpose of the directive, it's also possible to use that principle as such, saying that this is not the situation the directive is there for, and this shall not be treated in accordance with it. It's in practice maybe establishment instead, and there should be other rules applied. A more general comment is, of course, if we have problems with regulatory competition, and that is a general thing for union law, the answer to that is always that you must higher the standards than by harmonization directives, higher social standards in all the member states. Then you make it much more difficult to have that kind of regulatory competition because you have more equal laws in all the member states. I know that is difficult, but that is, I mean, the normal recipe of that kind of problems. And then just a few comment also on collective actions, because collective action is not in any way ruled out by, for instance, a Laval case or even the VikingLaval case. But you must have a legitimate claim in accordance with union law. So if you have that, as the same principle as your compliance with national law, then you can use collective action. But if it's going then in conflict with union law, then there is a problem, of course, to use collective actions. And I think there are many legitimate claims that one can try then collective actions. And then you have the VikingLaval case also talking about the principle of proportionality, which is a general principle of union law. So it should be applicable in many circumstances, but there are different applications of that principle, I think, and the last word is not said about how it should be used in this kind of context when it's collective action. And I think there are some scope for arguing that the collective action in an individual case is important in a much broader perspective, and I think it's possible to convince also the Court of Justice that even if this is going very far in this case, it's important for other reasons, because we prevent that kind of behavior in other circumstances and businesses in the future. So I think the last word is not said about that in the case law yet. We have very little case law about that in so far. So I think that brings me to the end, actually. Thank you very much.
Thank you, Jörgen. Do you want to comment on Jörgen's comments?
It's not a comment on the comments. It's just a statement. I think we are in agreement when it comes to the very clear analysis between the distinction of the principles underlying free movement of goods and free movement of capital and free movement of workers. And I think what is interesting is what is happening with the other freedoms. And if freedom of establishment was treated on a par as free movement of workers when it comes to the establishment of natural persons. You know, being in Sweden, the elephant in the room would be that Laval was in reality a freedom of establishment case, and we could have solved it in this way. But the European Court of Justice, we feel that over the past decade or so, has actually been trying to drag some of the persons out of the equal treatment Venn diagram, so to speak, part of the diagram, and drag them into the country of origin more and more. So, for instance, when it comes to establishment, we have the Italian case about solicitors' fees, which could be seen as an alter ego to the minimum wage regulation in the case of workers, but the solicitors lost because it seemed that minimum fees for solicitors' service were seen as barrier to market access. So what we are trying to argue, and I realize we're in agreement, and it's nice to hear this from somebody who specializes in EU law, is that there has to be a sphere of regulation within free movement law that pertains to persons and workers, whether they are subordinate or self-employed workers, and whether they provide services individually or as a set, as part of a company that is providing cross-border services. That has to be regulated in a way, in a view, according to the equal treatment principle rather than the market access or country of origin principle, which should apply to services that are not labor intensive but are capital intensive, and in particular when a service is labor intensive, it should be treated as being on a par with free movement of workers. And I think here you're making this very fine and correct distinction, but of what the European Union has been trying to achieve with the European Posted Workers Directive, sort of hybrid, intermediate regulatory environment. We fear that the ECJ has sucked the European Posted Workers Directive into the end of the spectrum that applies the country of origin principle more than it should. But it was, thank you very much. I mean, I think we agree on the analysis. Yeah.
Thank you.
Okay. Now there's room for comments and questions. Samuel, will you please give the mic to Alan Ball?
Yeah, you already have one.
Oh yeah, you
Oh, I can use my very own.
Yes.
Yeah, I can switch it on.
If I'm allowed to ask one question,
You jumped the queue. So, thanks very much for a fabulous presentation from both. And it's a question really about the kind of equal treatment principle. And a worry I have with the equal treatment principle, which is related to a deeper worry I have with the concept of equality, which I always think is an ambiguous principle, because equality can be satisfied by levelling up or levelling down. And my worry about the equal treatment principle is, without something else working in tandem with it, it's always vulnerable to the argument that where you have exclusionary effects on workers from poorer member states, then actually there's an equality problem going in the other direction. So I wonder whether it might be useful to supplement the equal treatment principle with an idea of dignity as an underpinning, because I think that is ambiguous, certainly, but are often used by equality theorists as a brake on levelling down and pushing the use of equality as a concept towards levelling up.
I think Simon and I were quite torn in respect of the choice of the principle that we'd like to see fit, and we did think about this transactional dimension. If could this have a protectionist effect, in effect, by excluding from the internal market of the host member states workers that the only thing that they can sell is really cheaper labor. But then we were looking, we're digging into Hansard, Hansard being the official journal, so to speak, the official collection of parliamentary debates in the United Kingdom. And when equal pay legislation was introduced in the United Kingdom, there was an interesting debate where an MP whose political affiliation is irrelevant said, hang on a second, equal pay legislation is actually going to be detrimental to women because all women can sell is cheaper labor because they do not have the same accumulation of human capital to sell. And believe it or not, you can find the reference. I won't tell you who the person is. And in a way, you can see this as applying perhaps more fittingly to the economic transactions between different member states that actually have a very different level of economic development and perhaps skills and human capital accumulation. Our thought is that a stronger application of the equal treatment principle may have some transformative effects in the kind of services that would be provided under the Posted Workers Directive, and may exclude, perhaps, some services that rely exclusively on the use or exploitation of the labor intensiveness of that service, and may reshape the market in favor of the exchange of services that are more capital intensive. And a lot of the services that are actually provided under the Posted Workers Directive are also services of that kind. So it's I think almost an unfair characterization to a Central and Eastern European service provider to suggest that all the kind of services that they manage to provide under posted workers arrangement are the kind of exploitative, low skill services. That is not the case. It may have an impact on that. And I think there is a lot of dignity that actually would come out of the equal treatment principle itself. But I'm almost refusing to engage with your question on the grounds of the fact that we think that in principle, the equal treatment principle is the right principle.
Now it's your turn.
Thank you. So I think the fact that abuse of law was mentioned really interesting, because I think that's one of the sort of elephants, legal elephants in the room, that actually certainly something like Viking could be characterised as an abuse of law scenario in a Keck style thing where traders are essentially trying to use the free movement provisions to challenge what's essentially a domestic regulatory choice. Why do you think the court has never really engaged with that abuse of law point?
I think the court has been very hesitant to use the principle of abuse of law when it comes to the treaty articles in general. And I think it was not raised in the case, if I remember well, by anyone. So the court maybe didn't have any obvious reason to discuss that principle in that light. But I think that principle has been developed much more when it comes to taxation, for instance, more recently. And it's much easier to apply that principle if you have a regulatory framework, you have a directive. And I think if you connect that principle to the Posting of Worker Directive and also the Enforcement Directive, which are coming to be applicable, I think there are more scope for that kind of reasoning in the future. And I am saying that there are some arguments which have not really been advanced. And one final point is, one good thing about the principle of mutual recognition is that it's still open, meaning that it's not only the justification grounds mentioned in the Posting of Workers Directive which are accessible, but you can also have some treaty-based justification or charter-based justification in addition. You can try that. I mean, you can see from the case where it's difficult, public policy is difficult to use, but it's not hopeless. If you have new kind of circumstances, you can have new argument, and then you can convince the court in a certain, maybe a little bit different direction in the future. But you must try the arguments when you have a good case.
Still room for one more question or comment? Petra Hertzfeld-Olsson.
Thank you. Thank you very much for this interesting presentations. And I've just one question which also relates a bit to Jeremiah's presentation, and that is about the responsibility of the national actors here. Because as you have seen, I mean, the effects of these two court cases has been very differently depending on how the national legislature has been responding to these two court cases. And I was a bit curious. It seems that the first fight has to be fought on a national basis. That's very clear both in Britain and also in Sweden, to use this room for maneuver. And has you been thinking about that? If the national legislature is not interested in taking this fight, who should do it in what way? Thank you.
Okay, thank you. Yeah, I mean, I agree with Petra that I think that the national legislature and also national actors in, I mean, trade unions, employers' organization have a responsibility for trying to handle this situation. I think you could say, and in particular in countries such as Sweden and the UK, which are institutionally a bit different in these areas, I would say that the national government has in a sense a duty to protect well-functioning institutions and try to find ways of implementing EU law, or also to deal with the effects of landmark cases that protect the national system. That is a value in itself. If you have well-functioning institutions, you should actually try to implement EU law in a way that protects these institutions. I also believe that is not necessarily in contradiction with the supremacy of EU law that Jeremiah has talked about, because it can actually be the most effective implementation of EU law. I believe that implementing EU law in a way that is compatible with the national system, that works well in the national system, but that works well on the ground, that works well out in each and every workplace, that can be handled by, as we have 94, our member unions have 94,000 or 95,000, sort of shop floor level officials out there. I mean, and you want to implement EU law in a way that they can actually handle, and then you should implement EU law in a way that is in accordance with the national system. Just one thing, Nicola has talked about a different project that we also have been writing on. Maybe you should mention what that project is and that it's actually being published now.
The European Labour Law Journal.
Yeah, we have written an article on exactly on the protection and protectionism issue, which is very sort of sometimes it comes up, and it came up also in Jörgen's presentation. We actually tried to go sort of to the bottom with the protection versus protectionism argument, and that is being published now in a couple of weeks. Yeah.
Okay. So, thank you, both of you. Now I invite Alan Bogg, who is going to give us the international law perspective on VikingLaval.